All right, let's spend a few minutes on just diving into some specific issues that we're seeing currently that EB5 investors are facing in the market today.
Yep. Yeah, and I definitely want to emphasize that a lot of these problems that we see are either preventable or easily solved as long as you've got a good attorney on advocating on your behalf, right? The first one that I think, the first two really that I think, are very easily identifiable, and an experienced immigration attorney will always do something to kind of prevent, is USCIS just completely missing the ball on which category you're investing into, whether or not you're actually current based on the visa bulletin, and basically just rejecting your adjustment of status as a result, right? This is pretty easily solved. A lot of experienced firms, both big and boutique, usually include some kind of cover page that shows very clearly that the person that is filing in this category, and they are current based on the current visa bulletin, and therefore are eligible to file an adjustment of status. This seems like such a small, minor thing, but it has really large implications, right? As we approach a backlog appearing on the visa bulletin, having an adjustment of status rejected, first of all, it takes weeks to know that it's even happened and then to correct it, right? You don't even know that you've been rejected, typically for about 2 to 3 weeks, and then you've got to go through the process of refiling, often with a new medical exam, and then basically waiting to make sure that that one got received correctly, right? So this is a timely error in the sense that it costs a lot of time to an investor, and it's very easily fixed by having a proactive attorney who's including that information right at the very beginning, so that whoever's in the mailroom and the officer that picks up the case doesn't improperly classify the filing and accepts the adjustment of status, so that the investor is now safe, essentially, from the sense of having an adjustment of status filed and received and accepted. Another pretty big one, and again, this seems pretty basic, and yet we see it often, is just not having the right documentation to show that an application even can be filed. So the visa bulletin has much more to do with the adjustment of status, but if you're an investor filing into an EB5 project, one of the basic things for, as opposed to RIA, if you're going into a regional center deal, is that you need to have a 956F, at minimum, proof of delivery, right? You want to have either proof of delivery, or then it goes up the ladder from there to either a receipt notice, or ultimately, if it's already been approved, the approval notice, right? And there's a lot of different ways that an attorney can mess this up by either not including any of these documents in the first place, leading to USCIS possibly rejecting it, or not even starting to adjudicate it. Second would be, knowing that it's not even knowing that it's happened yet, right? So a really inexperienced attorney not even knowing the questions to ask and saying, hey, you've chosen this project, I don't see a 956F, at least proof of delivery, can we obtain that from the regional center? So just completely, forgetting to ask for that and filing the application without it would lead to a rejection, or worse, it might even be accepted, and then months later you find out that there was no 956F proof of delivery at the time of filing, right? And now the case is going to be rejected. So even though if later on down the road you've now got that 956F approval, if at the time of filing there was nothing there to prove that the 956F had been received by USCIS, your case is ultimately going to be denied. So again, very, very minor thing that if you're an experienced attorney is one of the first things you look for. But if you're inexperienced, it could be one of those things that you just kind of forget to check, and could lead to a really, really big problem down the road.
Exactly. One thing I want to emphasize here is that these are again very small mistakes, but the outcomes are catastrophic, right? Not getting the EAD potentially ever, or years delay, or having to refile the whole application, perhaps not get the EAD again for years, but also have to spend $12,000 again and be delayed, several months with the filing for the green card. So, there's
Yeah,
major negative immigration implications if these mistakes are made. And so that's why it's just super critical to make sure you're working with someone who knows what to check for and is doing this, day in, day out on a regular, current basis. Because the mistakes the government's making today, are much different than the mistakes that were being made, 3, 4, 5 years ago. So if an attorney, is only doing a handful of cases a year, it's likely that they won't, you know, you don't want to be the guinea pig when the first time that error shows up on the attorney's desk and they're not, well versed in how to address it.
exactly, exactly. And to your point, Sam, I think the catastrophic downside to a lot of these is especially with the visa bulletin one, right? Like if you don't if for whatever reason USCIS just chooses to reject you, even if it's improperly, and let's say you've got something that's really important on the line. Let's say maybe you're running out of status and you need that adjustment of status to remain in the United States. Let's say that you've got a kid who's aging out and you need to get that application in before they turn 21. These are unfixable mistakes once you miss a deadline, right? Or it's a really uphill battle to get USCIS to basically nunc pro tunc it, which means basically go back in time and basically apply an earlier date to a filing because of a simple mistake. um, and so it's so important to have an attorney who understands one, what's on the line for each client and kind of what hangs in the balance, but two, just be super careful. Like we said at the very beginning, EB5 is constantly changing. There's, not volatility, but this is a relatively newer area of immigration law and it's constantly undergoing reform and change. And so having an attorney who's abreast of all those changes and is aware of all the different ways that USCIS can mess up and taking proactive steps to avoid that is going to be an attorney that gets you a better outcome.